Okay, hello everyone, and thanks for joining us today. Today we'll be hosting a presentation called Land Use Planning Reforms under Bill 139, A Public Interest Perspective. My name is Monica Paramba, and I am counsel at the Canadian Environmental Law Association. I'm joined by my colleagues Jacqueline Wilson, also counsel at SELA, and Jessica Carbon, our articling student. Just a quick note to say that we are recording this presentation today, and we'll stop the recording before the Q&A session. There is a chat box, and we invite you to write your questions into the chat box as you think of them. At the end of the presentation, we will go through them and answer them as best as we can. The link to this recording will be available tomorrow on SELA's website. Now, I should warn you that this presentation might be a little doom and gloom because we are quite unhappy with the amendments that have been made to the land use planning regime. And in particular, we believe that the new system makes it more difficult for the public to participate in important land use planning decisions in their communities. But hopefully this presentation can give you some ideas about how to best approach participation in the new system. So without further ado, I'm going to hand this off to Jessica to begin our presentation.
Thank you, Monica. I'd like to start off with a reminder to our audience that although we are talking about law and policy, everything presented today, including our answers to your questions, is legal information and not legal advice. If you require legal advice, you can contact us and we will refer you to SELA's intake process. SELA has been doing public interest, legal, and policy work for almost 5 decades. We are a specialty legal aid clinic. Our clients are required to meet eligibility criteria in order to retain our services. We often take on land use planning cases, which is why we have a keen interest in these reforms. For our land use cases, we typically focus on issues such as conserving water resources, protecting ecosystem functions, preserving prime agricultural lands, and safeguarding public health and safety. We have also taken on a number of query cases under the Aggregate Resources Act before the Ontario Municipal Board. We have also represented clients in landfill hearings before the Joint Board, consisting of members of both the Local Planning Appeal Tribunal and the Environmental Review Tribunal. We also participate in policy work, such as the periodic review of the Provincial Policy Statement and the Coordinated Land Use Planning Review. Here is a brief outline of what we will be discussing today during this webinar. We will first explain what Bill 139 is, and then define a few key terms and identify key legislation. We will then discuss some of the major changes and explain what this means for community groups seeking to participate in land use planning decisions in their communities. We will also tell you what we know so far about the Local Planning Appeals Support Center, and then we will finish off with a Q&A period at the end of this presentation. What is Bill 139? Bill 139 was introduced on May 30, 2017 and was passed by the Ontario Legislature on December 12, 2017. It will be coming into force on April 3, 2018. It includes the following 5 schedules. Schedule 1 repeals the Ontario Municipal Board Act and establishes the Local Planning Appeal Tribunal. Schedule 2 creates the Local Planning Appeals Support Center. Schedule 3 includes amendments to the Planning Act, the City of Toronto Act, and the Ontario Planning and Development Act. Schedule 4 includes amendments to the Conservation Authorities Act. Schedule 5 sets out other amendments, including amendments to the Aggregate Resources Act. For the purposes of this presentation today, we will be focusing mainly on the Local Planning Appeal Tribunal Act and the amendments to the Planning Act, and we'll briefly touch on a few others. Bill 139 has made some drastic and regressive changes to the land use planning system in Ontario. We are holding this webinar today to ensure that community groups know what has changed so that they can navigate the new system as smoothly as possible. We are going to dive into some details of the new LPAT regime, but first off, we plan to point out two drastic changes under Bill 139. First, the LPAT will no longer hold full hearings where parties can submit expert and other evidence. And second, the grounds of appeal have been made more narrow. We will go into more detail about this and the other changes. But before we do, we will define some key terms used in land use planning. The Local Planning Appeal Tribunal is the new tribunal replacing the Ontario Municipal Board Act. Replacing the Ontario Municipal Board. This presentation is all about the changes from the Ontario Municipal Board regime to the new Local Planning Appeal Tribunal regime. We will refer to the tribunal as the LPAT throughout this presentation. The Provincial Policy Statement, or PPS for short, is the broad statement of the provincial government's policies on land use planning, and it applies province-wide. An official plan sets out a municipality's general policies for future land use. Zoning bylaws put the official plan into effect. They control the use of land in a community by identifying how lands may be used, for example, residential, commercial, industrial. And lastly, an approval authority is responsible for approving, modifying, or refusing to approve Planning Act instruments such as official plans and amendments, zoning bylaws, and plans of subdivision. Depending on the Planning Act instrument, the approval authority might be the Minister of Municipal Affairs and Housing, the Municipal Council, municipal planning authorities, or planning boards. And now I will identify the key legislation and rules that you need to know about under the Bill 139 regime. The Local Planning Appeal Tribunal Act replaces the Ontario Municipal Board Act and sets out the constitution of the tribunal, its jurisdiction and its powers, and the practices and the procedures of the tribunal. The Local Planning Appeals Support Center Act creates the new Local Planning Appeals Support Center, which we will discuss later on in this presentation. Next, the LPAT rules control the practices and procedures of the LPAT. These rules are currently in draft form, and CELA has submitted comments on these draft rules, which are available to the public on our website. The Environment and Land Tribunals Ontario, ELTO, which is the cluster of tribunals that includes the LPAT, plans to revisit these rules in 6 to 8 months to see if changes are needed. Next is the Planning Act, and the Planning Act sets out the ground rules for land use planning in Ontario, and it describes how land uses may be controlled and who may control them. It provides the basis for public participation rights in land use planning decisions. And lastly, the Aggregate Resources Act provides for the management of Ontario's aggregate resources and controls and regulates aggregate operations. I will now turn the presentation over to Jacqueline Wilson. Thank you for listening.
Thanks very much, Jessica. I'm going to turn now to the substance of the changes to the land use planning regime. The amendments to the Planning Act now specify the only 3 grounds of appeal that may be advanced by appellants. The first is inconsistency with a policy statement. The second, nonconformity or conflict with a provincial plan. And third, nonconformity with an official plan. This is a key change. No other grounds of appeal can be raised, even if they are based on other planning considerations. So, for instance, under the previous Ontario Municipal Board regime, concerns about prematurity, land use incompatibility, nonconformity with provincial interests, and conflict with other provincial legislation, among other grounds, were available and commonly raised on appeal. That's no longer the case. If your appeal isn't based on one of these 3 grounds, the LPAT can dismiss your appeal without holding a hearing. We'll go over that new screening requirement in a few minutes. The amendments to the Planning Act also foreclose several types of appeals. Some of those changes are: there are no appeals of official plans approved by the Minister of Municipal Affairs. You cannot request an amendment to a new official plan or a secondary plan for 2 years after it comes into effect, unless you get permission from the municipality. And you cannot request an amendment to a protected major transit station area policy. These are the major phases of a Planning Act appeal at LPAT. The first step is to file a notice of appeal. The second, the tribunal will conduct a screening for validity. Third, the municipality or approval authority will provide the municipal record to the tribunal and every appellant. Fourth, the appeal record and case synopsis are due. The case synopsis is 20 pages and is like a factum, where you outline the facts of the case and the legal arguments you wish to make. Fifth, the responding municipality or approval authority may file a responding appeal record and case synopsis. Sixth, other parties and participants apply for that status 30 days before the case management conference is held. Next, that mandatory case management conference is held. And finally, there's an oral, written, or electronic hearing. There's a new process for screening Planning Act appeals in Rules 2605 to 2609. There was already an administrative screening process at the OMB, and that process is still in Rule 15 of the LPAT rules. This new screening process applies only to Planning Act appeals and is more substantive in nature. It provides that the tribunal will make a preliminary determination of the validity of the notice of appeal within 10 days of the registrar acknowledging receipt. If the tribunal finds that the notice of appeal is valid, the municipality, approval authority, or proponent can challenge that determination in an oral motion. This is alarming. We are very concerned that this new process will create an unnecessary roadblock for appeals and slow down the process for community groups trying to challenge a land use planning decision. The tribunal can also initiate a motion on whether the appeal can be heard. If the tribunal finds that the appeal is not valid, the appellant can challenge that decision, but only with a written motion. The next step in the appeal process is the municipality or approval authority must prepare a municipal record to be sent to the parties and the tribunal. The enhanced municipal record must contain a record of documents and materials used at the council level to reach its decision. The clerk of the municipality must also maintain a copy of the record and make it available to the public. Next is the stage of the appeal where an appellant files an appeal record and case synopsis. Rule 2612 tells you what needs to be in the appeal record. The appellants will point to the documents or parts of documents from the municipal record that they intend to rely on. There's also provision for an affidavit or statement by a person with knowledge setting out the material facts associated with the application. And where a person can be qualified to offer opinion evidence, that person's opinion with respect to the matters in issue can be outlined. Because no new evidence can be submitted to the LPAT, presumably the expert statement must relate to evidence already submitted at the council level. The case synopsis, as I mentioned earlier, is where you lay out your version of the facts in the law. The municipality or approval authority will then file a responding appeal record if they believe the appellant's appeal record is incomplete. The responding approval authority may also file a case synopsis. For most Planning Act appeals, a case management conference is now mandatory. If you want to participate in a hearing, you need to file a written submission that outlines the nature of your interest in the matter and how your participation will assist the tribunal. It's due 30 days before the case management conference. There are a few factors to consider in deciding whether to apply as a party or as a participant. In the past, the major difference between these two categories, parties and participants, is that parties had broad rights to call evidence and cross-examine witnesses. Now that is no longer the case because witnesses can't be called by any party. But note that in some Planning Act appeals, for official plans, official plan amendments, and zoning bylaws, participants are not allowed to participate in the oral hearing if one is held. Another factor to consider, parties are exposed to costs, but participants aren't. The tribunal also now has a power to appoint a class representative to represent two or more parties with common interest. The tribunal will decide at the case management conference whether the hearing is oral, electronic, or written. They will also set a date for the hearing. The Environment and Land Tribunals Ontario has said that they will no longer canvass the parties for dates before scheduling the hearing. On the previous slide, we mentioned a few considerations to look at when you decide whether to participate as a party or a participant. We also want to mention that the rights of non-appellant parties have been drastically reduced in the new system as compared to other parties. The proposed Rule 8.03 states that a non-appellant party may not raise or introduce new issues in the proceeding. Instead, the non-appellant party has to shelter under an issue raised by an appellant. As well, and this is very important to know, a non-appellant party has no independent status to continue an appeal that is withdrawn by an appellant party or is otherwise resolved or determined by the tribunal. So if you disagree with a municipal decision, you need to carefully consider whether to appeal, even if you know another party may be appealing. It matters a lot whether you are the appellant party or you are granted party status later in the case management conference. Okay, I'm going to turn this over to Monica.
Thanks, Jacqueline. So now I'm going to look at the new evidence rules at the LPAT. The hearing process has been dramatically changed by Bill 139 for Planning Act appeals. Planning Act appeals are no longer going to be full hearings with evidence. There are no witnesses, including experts. In the new regime, you have to rely on the evidence that was before the municipal council or approval authority. The bill has turned the LPAT into an appellate review body, but with a far less robust type of appellate review. On a judicial review in court, the court will defer to a specialized administrative body whose decision it is reviewing. That administrative body has usually heard and considered all of the evidence and made a determination on the merits. Here, the LPAT is deferring to a municipal council. Municipal councils and approval authorities differ across the province, but one thing is true for all of them. There is no robust or transparent testing of evidence or competing opinions before they make their Planning Act decisions. For instance, you can't cross-examine a proponent's land use planner at a municipal council meeting. Under the new system, there is no way to test that evidence at any point in the appeal process. These new rules are also problematic for new evidence that comes to light between the municipal council decision and the LPAT appeal. By the time you get to the appeal, there's a chance that some of the material is out of date, that site conditions have materially changed, that information needs to be clarified or supplemented, that new relevant testing has been done, among other things. None of that evidence is going to be allowed at the LPAT hearing. The tribunal, however, may call witnesses. The tribunal can examine a party to the proceeding, examine a person other than a party who makes a submission to the tribunal in respect of that proceeding, require a party to the proceeding or a person other than a party who makes a submission to the tribunal in respect of the proceeding to produce evidence for examination by the tribunal, and require a party to the proceeding to produce a witness for examination by the tribunal. It's a possible way for new evidence to be heard in the appeal, but we will have to wait and see exactly how the rule is used. The development of the record is no longer in control of the parties. There is also one very narrow way for parties to get in evidence that wasn't heard at the municipal council level. The rule allows some documents or materials to be added to the appeal record if the document was available to council but was not included in the municipal record. The document should have been available to council, but by reason of it being in the possession of the municipality, it was not put before council, or if there is a non-decision, the proponent can update their application. None of these provide much room for community groups to get in new evidence at the LPAT. So the most important takeaway from this presentation is to get involved early, before any municipal decision is made. It was always the case that you had to participate in the statutory public meetings held by the municipal decision maker to get appeal rights. But the new evidence rules mean that if your municipal decision maker makes a decision that you do not agree with, you will no longer be able to build your case after that point. You need to participate with that in mind. With the small exceptions we mentioned, the LPAT will be restricted to the record that was before your municipal decision maker. This means that you need to get any expert evidence in at the municipal level. And if it is possible, have your experts respond to the proponent's evidence. It has been our experience that different municipal decision makers across the province do not have equally robust processes. This is one of our major concerns with the new process. Do your best to anticipate issues that will be important and have experts address those concerns if you can. Seek the advice of a lawyer, a planner, and any other technical experts as soon as you can. The common practice to wait until the OMB hearing process to hire experts is no longer going to be adequate. We anticipate that this is going to be very difficult for community groups. It will be more difficult to know what information you need to respond appropriately to a proponent's application, and you are going to need to spend money on experts before you even know if there will be a decision that you don't agree with. We also expect it will be more difficult to fundraise money to hire experts because their work will come before a decision has been made. Try to familiarize yourself with the procedures of your municipal council or approval authority. Each municipality should have a procedure bylaw that governs how to speak at council meetings, time limits for presentations, limits on the number of presentations per meeting, and timeframes for their decisions. If you can't find the bylaw that your municipal council uses, request that they send it to you. So hearings at the LPAT can now be held in written, electronic, or oral form, and this decision will be made at the Case Management Conference. These rules about the nature of the hearing are not restricted to Planning Act appeals. Rule 21.01 suggests that written hearings will be held unless a party satisfies the tribunal that there is a good reason for not doing so. If you receive a notice of a written hearing, you have 10 days to object to it. Rule 21.02 lists the factors that the tribunal may consider when deciding whether to hold a written hearing, and Rule 20.05 lists the factors that the tribunal may consider when deciding whether to hold an electronic hearing. If the LPAT decides to hold an oral hearing, the time limits for oral submissions are quite limited. If you're a party to the appeal, your oral submissions must not be longer than 75 minutes. If you're a participant, then your oral submission is limited to 25 minutes. However, the tribunal can extend times if it determines that the extension is necessary for fair and just determination of the appeal. If the LPAT allows an appeal, they are required by the Planning Act to now send the issue back to the municipality or approval authority to make a new decision. The tribunal may provide reasons, or they may choose not to. The municipality then gets a chance to make a new decision. It has 90 days to do so. If you still disagree with that new decision, you will need to appeal to the LPAT a second time. This is another problematic aspect of this bill because it increases costs for the public by making Planning Act appeals in 2 stages. On the second appeal, the LPAT can make a final determination. The second appeal at the LPAT is very different from the first, if you can survive the long, arduous journey to get to that point. On this appeal, you would get a full hearing, including examination of witnesses, exchange of documents, and discovery. There are also new time limits for Planning Act appeals. They are found in Ontario Regulation 102.18. This is another area of concern for CLAB because setting arbitrary time limits ignores that some Planning Act appeals are quite complex and others are more straightforward. The time limit starts once an appeal is validated, which means that your appeal has survived the preliminary screening process. The time limits include everything from that point to the decision being made by the tribunal, but does not include adjournments. The time limits are different for different types of appeals. It's 12 months for the failure of an approval authority to make a decision on official plans or on plans of subdivision. It's 10 months for decisions by municipalities or approval authorities on official plans or zoning bylaws, 10 months for failures of a municipality to make a decision on official plans or zoning bylaws, 6 months for appeals of new decisions, and 6 months for any other Planning Act appeal. The consequences of failing to meet these timelines is not spelled out either in the legislation or the regulations, so it's unknown at this time what will happen if a matter is not resolved within the required timeframes. We wanted to raise a few last points about the costs of this process. There is a $300 filing fee for an appeal. You have to pay the $300 fee again if you appeal a second time after a new decision by the municipality. There's also likely to be increased costs almost every step of this process. As we mentioned, there are costs associated with hiring experts earlier in the process. You will likely need to have an expert retained during the first municipal council decision, during the first LPAT appeal, during the new municipal council decision, and during the second LPAT hearing. And that's only at the administrative tribunal level, never mind possibly appealing a decision to the courts. Finally, in deciding on how to participate in the appeal process at the LPAT, it is important to know that participants are not subject to costs, but parties are. As was possible at the Ontario Municipal Board, different related planning matters could be heard in one hearing. For instance, any matters referred to the LPAT, such as ARA license hearings, can be combined with any related Planning Act appeals. However, this will be more complicated because some issues will still get full hearings, while the Planning Act matters we mentioned today are only subject to the curtailed hearing process. There is no rule addressing exactly how this will work. For joint board hearings with the LPAT and ERT, the panel hearing the appeal will decide whether to apply the LPAT or ERT rules to the joint hearing, so that hasn't changed. During the transitional period, there will be cases before both the LNB and the LPAT. There are likely to be sequencing issues where one Planning Act matter may be before the OMB and a related Planning Act matter will go to the LPAT. If there are specific sequencing issues that you are concerned about, the best idea is to reach out to the case coordinator assigned to your appeals, flag the issue with them, and that will begin a conversation on how the parties would like to proceed. The transition period is likely to be confusing at times, and good communication between the case coordinator, the parties, and the tribunal member is going to be very important. So the LPAT Act and the Planning Act amendments, as mentioned before, come into force on April 3rd. Ontario Regulations 6718 and 10118 contain the transitional rules to determine whether an appeal will fall under the old OMB regime or the new LPAT regime. There are detailed provisions about which system applies depending on your particular circumstances. Take a look at the regulations, and if you're unclear where your case falls, you can ask us or another lawyer for assistance. Although we have focused this presentation on the Planning Act amendments, we did want to point out that a major amendment was made to the Aggregate Resources Act in Schedule 5 of Bill 139. If the Ministry of Natural Resources and Forestry refers an ARA license to the LPAT, there is still a full hearing. However, if the LPAT directs the minister to issue the ARA license subject to specified conditions, the minister can refuse to impose such conditions if he or she is of the opinion that the conditions are not consistent with the purposes of the ARA. The purposes of the ARA are quite broad and include the broad purpose of providing for the management of aggregate resources in Ontario. This amendment has the potential to give the minister wide-ranging and unilateral discretion to refuse conditions that the LPAT deemed were necessary after considering the evidence and arguments from the parties to the hearing. It's essentially an open-ended political override. Bill 139 also establishes the Local Planning Appeal Support Center, which is independent of LPAT. There are not a lot of details yet about LPASC, but the Act lists the types of services it will provide: information on land use planning, guidance on tribunal procedures, advice or representation, and any other services prescribed by the regulations. SELA has repeatedly raised concerns about imbalances in the current land use planning system, in particular the unfairness that arises from having well-resourced developers and approval authorities face off against under-resourced community groups. We are disappointed by the scope of the LPASC and do not think it goes far enough to alleviate these concerns. LPASC will not be providing funding to community groups, and we suspect representation services will be limited. Because LPAT hearings are so restrictive, the opportune time for assistance is early on in the process at the municipal level, but it is unclear whether LPASC services will be available that early. Bill 139 establishes a financial eligibility test for LPASC services, although we do not yet know what that test will be. We know the LPASC is hiring planners and legal counsel, but we do not know whether other technical experts will be hired as well. So that's everything that we wanted to cover today. We're going to break for about 5 minutes, and then we'll take any questions that you have. Thanks.